Broadcasting from Salisbury University campus, this is WSDL Ocean City, NPR News Talk 90.7. Putting Delmarva first. Stay tuned for Delmarva Today with your host, Don Rush.
Good morning and welcome to Delmarva Today. I'm Gretchen Hansen, sitting in with my co-host, Don Rush. Last week, the president promised to select someone with impeccable credentials, great intellect, unbiased judgment, and deep reverence for the laws and the Constitution of the United States. In the wake of President Trump's announcement on Monday to nominate Brett Kavanaugh as the next Supreme Court justice, every decision, ruling, and speech in his 30-year legal career has been dissected and torn apart to determine what his positions are on certain hot-button social issues. We're here to look at some of those questions. I have with me guest Thomas Jipping, Deputy Director of the Edmund Meese III Center for Legal and Judicial Studies and a Senior Legal Fellow. Good morning, Mr. Jipping.
Good morning. Thank you for having me.
Thank you for being here. And I have with me Ms. Anisha Singh with the Center for American Progress. Good morning.
Good morning. Thank you for having me as well.
Thank you for being here. I'd like to start with you, Mr. Jipping. It has been said that Kavanaugh was one of the most controversial of those frontrunners for the Supreme Court. Why do you feel he was chosen to be the judge by President Trump, and what are his strengths?
Well, I don't agree at all that he was controversial. He was chosen for the President Trump's list for the reason that the others were, and that's his judicial philosophy, his approach to judging. The common theme among the front runners, so-called, for this nomination, but the other judges who are on that list, the common theme is that they will approach the law as written. They will approach statutes in the Constitution as written, taking as much of their own views out of the equation as possible. And that's important because the law and not the judge should really decide cases that come before the courts, and that's the best way to make that happen. And his record shows that. He's committed to it. He's represented that view since even before he became a judge on the U.S. Court of Appeals. He's been there for 12 years, and this is reflected in the opinions that he's written there. That's the kind of judge that our country needs, and that I think our system of government really requires, and that's the kind of judge that he's going to be.
Thank you. Ms. Singh, what do you feel concerns liberals the most about his nomination?
I think there's a few things here. One is, President Trump made it very clear on the campaign trail and throughout his rhetoric that he's going to choose justices that hold up to his litmus test of overturning Roe. Women are concerned that Kavanaugh has been selected with that litmus test already tested. We know personally from Kavanaugh's record that he has, said that he agrees with the dissent in Roe. And so that's one concern. Another is Kavanaugh himself has written a dissenting opinion in a case about the Affordable Care Act that would have allowed an attack on the health care of millions of Americans. We've seen already that this country has made it clear to Congress that they do not want the ACA to be dismantled. That was a fight that we already had last year, and the worry is that now the judiciary will take it up, and it is something that Kavanaugh will not speak for the people on. And another huge concern is, there was a list, as was stated, of different nominees, but this is a particular nominee that has said that the president has absolute discretion to determine whether and when to appoint a special counsel, and also that a sitting president should not be able to be criminally indicted. Which is very interesting to us, given everything that is happening with the Mueller investigation and all of the questions that might end up in the court about, Trump and whether or not he can pardon himself from that investigation. The fact that this specific nominee has outrightly said that shows the loyalty that is required. And a lot of us are worried about what other loyalty tests have had to happen for this nominee to be the nominee that has been chosen.
In terms, by the way, of Tom, I'm going to turn to you for a moment, that this nominee comes from a list that was supposed to have been drawn up by the Federalist Society, which is seen as a politically and legally conservative group of people, as opposed to, say, someone who might be, say, on, say, a list of, say, Hillary Clinton, for example. And it's the Federalist Society is seen as having sort of almost in some ways stacked the court, as it were, although there's some dispute about that. What do you make of that? Because that's going to become part of the political discussion that's going to take place over this nomination.
Sure. Well, of course, a private organization can't stack the courts. But I first want to take issue with the last thing that was said about Kavanaugh's record. It was a complete misrepresentation of what he has said and written with regard to presidents being sued or investigated. Judge Kavanaugh gave remarks at the University of Minnesota Law School in 2008 that were published in their law review. He acknowledged that the state of the law today is that a president can be sued and a president can be investigated while in office. He suggested that Congress consider legislation to defer suits or investigations until after a president is out of office so that the president could perform his duties, and that was on the basis of Kavanaugh's own experience in the White House. It is absolutely not true that Kavanaugh expressed his own view that the president can't be sued, can't be investigated. That is absolutely false. And this is the kind of really misrepresentation and misleading of the American people, not just about Kavanaugh's record, but about what judges do in general, that is really undermining the integrity of this process. As to your question, the list gets attention only because he's the first candidate or the first president to actually name names. Every presidential candidate talks about his judicial appointments in some way, and every administration receives tons of input and suggestions of all sorts from their allies, allies, left and right. This is hardly the first, but this is the 11th Supreme Court nomination that I've been involved in, and I know that every administration receives suggestions, but that every nomination is the product of that administration. As I said at the top, a private organization can't stack the courts.
Anisha?
Yeah, I mean, going back to the first thing, we have an exact quote that Kavanaugh did say that the president has absolute discretion, and that is what I'm quoting here, and that is what is worrisome, especially given everything that is happening with this investigation. But given that list, the 25-person list, and the Federalist Society, we know what they have been packing our lower courts with are also judges that have had blog posts that are comparing affirmative action to slavery. That, you know, we had a nominee in the lower courts that was saying transgender individuals are the work of Satan. I mean, we have some extreme statements coming from some of these very extreme nominees in our lower courts, which kind of gives us an idea of some of the names that are being thrown around by the Federalist Society, Judicial Crisis Network, Heritage Foundation, and other groups that are kind of feeding this president with all of these judges that he is now using to pack the courts, as you have stated. And we have a real crisis here because there are hundreds of vacancies, over 100 vacancies that this president came in and adopted, and they have been packing the courts. They've been getting rid of procedure and traditions that we've had in the Senate for a very long time, whether it's the nuclear option that was used for Gorsuch, and then the blue slip rule that has basically been tossed aside, a 100-year tradition there for lower court nominees, where it's basically stated that home state senators had a say in whether or not a nominee should be, put forward for lower courts. That is now gone. So we're seeing this process kind of also be created where Republicans have taken the judiciary and used it as a tool and an avenue for them to pack the courts with these extreme nominees who are, in my opinion, very dangerous for our society.
So, Mr. Jibbing, Kavanaugh said when he was confirmed to the D.C. Judicial Court that he would follow Roe v. Wade faithfully and fully. What do you feel the chances are in case of a challenge? Will Kavanaugh follow precedent of the Supreme Court on social issues, and why or why not?
Kind of cancel each other out. But what I do want to emphasize is that the quotes that you heard were, first of all, not from anybody on President Trump's list, and I thought that's what we were talking about. But also, this is another example of how they're misleading the American people about what judges do. The fact that someone had a blog post and made a comment about a particular issue, the question is whether judges ought to make decisions based on their personal views. I take it the Center for American Progress believes that they should. The Heritage Foundation believes they should not, which means I really care less. I couldn't care less about what someone's personal views are on miscellaneous issues. If they're going to be a judge, I want to know whether they're going to use their personal views, whatever those views are, to decide their cases. Judge Kavanaugh won't, and that's why he's going to be a great judge.
Turning to the issue of abortion, what prospects do you think that they may vote to say overturn, or do you think he'll simply, as some of the critics say, chip away at Roe v. Wade? What's your sense about that, Tom?
That's more complex than simply what will one judge do. Sure. Obviously, the Supreme Court can't do anything unless a case comes to them. Here, too, a lot of Americans probably believe that judges, and I spent 15 years in the Senate working on the Senate Judiciary Committee, a senator can get up in the morning and introduce a bill on anything he wants to do anything he wants. Judges can't. Judges can't do anything until a case comes to them. So a lot of planets would have to line up for a particular case to get all the way to the Supreme Court that would really urge the court to revisit Roe versus Wade. They've had many opportunities to do that and haven't done it. That prospect, I think, is very unlikely. And frankly, predictions about what individual judges are going to do on certain issues are notoriously wrong. So the scare tactics of I've actually heard or seen some commentators or seen some tweets or something saying that within 18 months, a certain number of states are going to ban abortion. None of that is true. None of it. And again, it misleads the American people about what the courts do and how they're involved in this issue.
Ms. Singh, I'd like to go to the Health Care Act and talk to you about contraception. What do you think the possibility that freedom would be chipped away, the right to contraception for women?
Sorry, I want to address a couple of things that were said, though. We're not saying that we want justices or judges who are bringing their personal views outright into what they're doing. We're saying that happens, and we know that the law can be interpreted in different ways. The reason that the Supreme Court is there is to take cases that are not clear and decide whether or not it should go one way or the other. And personal bias does always play a part. And what we're saying here is when someone has such extreme views that they have explicitly announced, whether in a blog post or through their other cases, we know which way that they are going to tend to gravitate on those things. And if you're saying something as extreme as what I was saying previously in my example, affirmative action is like slavery, we know, what kind of bias will come into play. What we're hoping is that people are not saying things like that and are not viewing their outlook is not as such, and that they're not bringing that into the courtroom. In terms of Roe and contraception, again, like I said, we know that Kavanaugh has agreed with the dissent in Roe, and that is the concern here. We know that he has wrote a dissenting opinion about the Affordable Care Act as well, a case that challenged it. And so that is also what we're going off of. We're going off of his precedent, his own record on the case. And there's over almost 3,000 documents that have to be reviewed by the Senate before this nominee can go through. And I think we're going to see a lot more revelations on how Kavanaugh thinks about these issues. But for me personally, this is not something we want to risk. I think it has been okay in the past for a nominee to say, well, I'm going to follow precedent. I'm going to see whatever case comes before me. I can't really decide right now. But what we know is there are lower court cases coming out of Texas. There was a headline I read the other day. Texas wants to test abortion case in new Supreme Court coming their way.
Okay,
this is not an issue that we want, to jeopardize and play Jeopardy with and gamble with. This is women's lives. This is their autonomy. This is their bodies. This is life and death for some women who have health risks. This is emotional security, economic security. So we don't want to be taking a chance with someone who cannot explicitly say that, yes, I recognize a woman's autonomy. I recognize that Roe is the law, and that we need to uphold a woman's right to safe and legal abortion.
Anisha? Yeah, Anisha? Yeah, Tom, yeah, it's go ahead and respond. I want to get you in here.
I think most people know that judges are supposed to be impartial. You go before a judge, you have a case, whether it's a civil case, a criminal case, you go before a judge, you don't want to believe that that judge has already committed to the issue that's involved in your case and therefore has already, in a sense, prejudged your case. That's not what judges are supposed to do. The best response to that politicized view of the judiciary is Ruth Bader Ginsburg. In 1993, in her confirmation hearing, she said that she would give no hints, no forecasts, no previews, because doing that would actually show disdain for the entire judicial process, and that's the truth. A judge, including Judge Kavanaugh, who is a sitting judge, they take an oath to render justice impartially without regard to who the parties are. And this demand that a judge sit there under oath and tell the Judiciary Committee how he's going to rule in cases he hasn't even seen yet is absolutely contrary and virtually destroys the oath of office and the impartiality and the independence that's at the heart of what makes our judiciary so great.
I mean, I hear that, but I also think that this nominee has a record and has said things already. And has dissented already, and so we are questioning that, and he has some explaining to do there. We have seen that on the flip side, when Obama had nominees, those same questions were asked of those nominees as well. So this is not new. We want to know what exactly is going on and where he's going to be ruling, because this is a lifetime
those questions were asked, but Obama's nominees gave the same answer that Ruth Bader Ginsburg did. Both Elena Kagan and Sonia Sotomayor explicitly refused to talk about their personal views related to issues that could come before them. In fact, Justice Sotomayor was even the strongest. I mean, they both refused to do it. They were right
That's
to
actually
refuse
not
to do it.
true. Ruth Bader Ginsburg was very open.
The impartiality of a judge is more important than either a conservative or liberal political agenda.
I want to, Tom, if I can keep you on the line, and want us, we're going to say goodbye to Anisha. She's from the Center for American Progress.
No, the other way. The other way. Sorry.
Right.
Okay.
So Anisha, thanks for that. We're going to get the other person on the line here in a moment. So Tom, there's the other issue. There's sort of this issue about what they call the administrative state, which I guess covers everything from the EPA, the Consumer Financial Protection Bureau, and he's described, I guess, these agencies as independent agencies collectively constitute a headless fourth branch of the U.S. government. What do you make of this pushback on what is an administrative state in terms of how much what there should be, and particularly in a society that's certainly far more complex than, say, the late 18th century when we were all trying to put this thing together?
Oh, Anisha, are you still there? No, we don't have anything.
Yeah, hi, Anisha.
Oh, okay. Tom had to go.
Thanks for sticking with us. Anisha, did you hear the question, or shall we repeat it?
Yeah, if you could repeat it, please.
Yes, in terms
I was
of
just listening in.
Yeah, that's all right. In terms of the administrative state, we have there's been criticism of the administrative state in terms of the EPA, in terms of the Consumer Financial Protection Bureau, and so on. He's described, by the way, independent agencies collectively constituting a headless fourth branch of the U.S. government. And the complaint, particularly from conservatives, has been that, well, Congress certainly has the basic responsibility to put on, as it were, the laws, to pass those laws. They have to be carried out. Have we struck maybe an imbalance when it comes to what these agencies do as opposed to what Congress had envisioned?
So I actually, I have not read too much into this, but what I can say is, there are a lot of questions that are coming up right now about how the government is run because of how this particular president has been running things, how many people have been hired and fired and appointed and questioned thus far. So I think there is a lot to be said for, the processes that we are seeing. I mean, we were just talking about the judiciary, whether or not the processes that Mitch McConnell has kind of overthrown. What are the protections we have in terms of how much leeway a president has in that, and how much leeway a Congress has in the rules that we follow. So that's something to be keeping in mind in terms of what the processes are now in terms of who we're appointing and putting into agencies as well.
I'd like to welcome Elliot Minh on the line. He is a senior fellow at the People for the American Way. Thank you for that response, Anisha. And I'd like to direct a question to you, Elliot, if you don't mind. How many people believe that Justice Kennedy had some say in the nomination of Kavanaugh? And do you think Kennedy was aware that he was the front runner and he was comfortable with that choice? Since Kavanaugh clerked for Kennedy, do you think this is why he was comfortable about precedent being upheld?
Well, thanks for the question, and I'm happy to be with you. That's a very good question that I'm not sure we'll ever know the answer to. There's no question that Kennedy must have realized that Kavanaugh was a possibility. He was on the list of 25 that Trump said he would choose from, and there's no question that that might well have been a factor in Kennedy's decision, which basically in many ways was a gift to the Republican Party to have resigned as he did a fairly short period of time before the midterms. This will undoubtedly excite their base, as well as, we hope, exciting and terrifying those on the other side of the fence who are concerned about what Kavanaugh could do to our rights and liberties.
So Kavanaugh is being defined as an originalist in terms of interpretation of the Constitution. Can you explain what that word means and why that's accurate?
That's another excellent question, because it means different things to different people. The idea of originalism is to say that the Constitution should be interpreted according to the original intent of its framers and its language. Well, what does that mean? What does that mean when it comes to broad terms like equal protection and due process of law? There was a decision a few years ago on the school prayer issue where Justice Scalia claimed that originalism meant that graduation prayer endorsed by the government should be allowed. Justice Souter matched him historical piece for historical piece and demonstrated that, in fact, what the framers meant was to say the government shouldn't be endorsing religion. So that's what it means, but or that's its definition. What it means depends a lot on who you talk to.
So there was and I don't remember which opinion this was, but there was an opinion rendered about a Subway that they denied religious ads during the Christmas season. And that was one of the opinions that Judge Kavanaugh rendered against. And he said it was right to free speech to have a religious ad. Am I correct in that? And can you explain that in context of what you were just saying about religion?
I do vaguely recall that case. It's not one of his dissents, which we've been focusing on particularly recently, but the argument is that there is a free speech right to put materials up, and if the forum, if you will, of ads on a bus or a mass transit system is sufficiently open, it's difficult to say, well, in terms of being constitutional, it's difficult to ban ads that have a particular religious or other content. I think that was the basis for the decision.
How much in terms of religious liberty? We seem to have this intersection between, on the one hand, we certainly have religious liberty in terms of churches and so on, but it seems to me that we get into difficulty when we start moving religious folks into sort of the public square or the commercial square. And I'm thinking particularly of Hobby Lobby as an example, in which this is a business, this is not a religious institution, for example. However, the court has said, well, in this particular case, for this particular kind of a business or company, we need to take that into consideration. What about that intersection that we seem now to be seeing between religious liberty on the one hand and yet commercial and public square issues on the other?
Well, it's a very good question. We've always felt, in the court of traditional view, that the religious liberty protections of the Constitution should be seen as protections, as a shield against government action that infringes on people's religion. But what is beginning to happen among some far-right advocates is that religious liberty is turning into a sword that's being used to puncture other people's rights, like the rights of LGBT people in some states to not be discriminated against when it comes to public accommodations. And that's been a serious problem that, again, will only get worse with Kavanaugh. He already rendered one dissent in one decision where he argued that under the ACA, if a religious organization didn't want to provide contraceptive coverage, they could even be exempted from saying publicly to the government and to the insurance company, we don't want to provide this coverage, because what happens under those circumstances by operation of the law is that the insurance company provides the contraceptive coverage. But their position would essentially have denied thousands and thousands of employees contraceptive coverage to which they were entitled under the ACA. Kavanaugh argued that these religious employers ought to be able to do that. That issue is still unresolved. The Supreme Court sent it back to the lower courts to try to work things out, but I wouldn't be surprised at all if it doesn't get back up to the Supreme Court, and we have significant reason to worry that balance will move towards making religious liberty a sword rather than a shield under Kavanaugh.
So this has been referred to as weaponizing the First Amendment in several of the articles that I've read. Could you give us some examples of what that means?
Well, there are very good examples on the other part of the First Amendment, free speech. This was talked about in a strong dissent by Kagan just this year in the case involving unions, where the Supreme Court overturned precedent going all the way back to the 1970s that said that when unions essentially provide services to non-members in collective bargaining, that those members can be charged by the government a fair share fee to help the union keep going. The conservative majority, including Kennedy, unfortunately, ruled that violated the First Amendment, and a very good example of weaponizing it to harm others in significant ways. There are other examples as well. The campaign finance decision, Citizens United, is an early example of that, and it's a tendency that we've seen a lot of. Again, going back to Mr. Kavanaugh, he tried to use it in a case involving the FCC. They had, before President Trump's nominee got rid of it, a very important net neutrality rule that made sure that when Internet companies represent to you that they're going to give you free choice in what you look at, they can't go back on their word. The FCC said there has to be true net neutrality. The D.C. Circuit upheld that. Kavanaugh dissented, saying it violated the First Amendment.
Do you think that we're, just quickly on this issue, do you think we're headed back towards what's been considered the Lochner era, which basically a legal philosophy which upended government intervention and regulation of businesses?
I hope not, but I fear that we may well be. The prime judge picker of President Don McGahn, his White House counsel, made very clear that one of his prime criteria in picking or recommending Supreme Court nominees that applies both to Gorsuch and Kavanaugh are people who want to, quote-unquote, dismantle the administrative state, otherwise known as returning to the Lochner era, not having agencies that are in there to make sure that we have minimum wages, that we have maximum hours, all of the social safety net protections that started with the New Deal. The Federalist Society and others have long espoused a philosophy that says that shouldn't happen, because it should be up to private corporations and private industry. And I think it's quite possible that we may see, with the kinds of judges that are being appointed in the lower courts, and if Kavanaugh is confirmed to the Supreme Court, a significant return to that discredited Lochner era.
So, Elliot, in that vein, do you believe that the Second Amendment, as it is originally intended, will be upheld as well? Because you're talking about a return to things as they were originally intended with these decisions, or...
You raise a very good point. It seems to me, the Supreme Court said for many years, that the original intent of the Second Amendment was to ensure that there could be well-regulated militia, not to see individual purchase and use of sometimes even dangerous firearms. I fear that given the conservative nature of the Supreme Court, even if Kennedy was replaced with someone like himself, Kennedy, it's unlikely that will happen. But again, with Kavanaugh, we go even further. Kavanaugh wrote another dissent.
In terms of?
I'm sorry?
In terms of the, sort of wrapping up, what kind of prospect do you think there will be for, say, for instance, this nomination getting through, or do you think it's going to have that much trouble?
Well, I think it's going to be a very tough fight. It will come down ultimately to 4 or 5 senators, I think. A couple of Republicans like Collins and Murkowski, 2 or 3 Democrats, and if 4 of those 5 senators vote against Kavanaugh, as we hope they do, then the Kavanaugh nomination can be defeated. That's a tough road, but it's possible to do. And we are encouraging all of our members all over the country to express their concerns directly to senators, and we'll just have to see what happens.
Mr.
It's not an
Minchberg.
easy fight, but it's possible.
Mr. Minchberg, I'd like to thank you for being here. That was Elliot Minh, the Senior Fellow at the People for the American Way. Our other guests were Anisha Singh for the Center for American Progress and Thomas Jipping, the Deputy Director of the Edwin Meese III Center for Legal and Judicial Studies. I'd like to thank you for tuning in today to Delmarva Today. I'm Gretchen Hansen with my co-host, Don Rush.
Thank you for watching Delmarva Today, a production of Delmarva Public Radio. Production and audio engineering by Chris Frank. Hosted by Don Rush. For podcasts, visit delmarvapublicradio.net or subscribe to the Delmarva Today podcast on iTunes. Delmarva Today can now be seen on Pack 14.